Hi there and welcome to Employment Hour in 30. I am John Scholes. He is Lior Samfiru. We are back in action and ready to go. We're talking about employment law, workplace rights, and everything under that very wide umbrella. The place where you spend, unfortunately, most of your life is working and making money and feeding your family. So you got to know your rights. You got to have your ducks in a row when it comes to your rights. And what you need to know, we got a ton of stuff on the show today. We're going to be taking some phone calls from our live employment law radio show, which you can find at employmenthourtv.ca. By the way, that is the website. And to reach out anytime, 1-855-821-5900. That and some emails on the way. But we always start, my brother, with the week that was, some cases that have been happening on your desk and in the firm. What do you got for me?
Well, actually, it was actually recognized on the street the other day. I thought that was kind of neat.
Great.
Yeah, so
that's going to help the ego.
That's not going to help the ego. No, the ego is getting bigger. But it was nice, and I appreciate people watching this show, and I appreciate people giving me feedback on it. Luckily, I get to spend a lot of my time talking to people about workplace rights. As you said, it's a very important topic. It's a very important topic for all of us because we all have jobs. So we're here to educate and inform, and I'm gonna. By the time we're done here on every show, you're going to have a master's degree in employment law. You're going to know a lot about your workplace rights. So we always want to make sure that you know that there's solutions to your problems. If you're dealing with an issue in the workplace, if we don't cover it right here on the show, call me, email me, talk to me about your specific situation. I promise I can help you out. But week there was where we start, John, situation that came across my desk. I spoke with an individual that for the past 6 or 7 years, as long as he's worked for his company, has worked rotating shifts. So sometimes he'd work days, other weeks he'd work nights.
That's tough, man.
It's tough, it's exhausting, but a lot of people do it, and him and his coworkers at this particular company all did it. And he was fine with it. He was okay. He liked having that kind of flexibility and no problems. Except recently he was diagnosed with a medical condition, has to take medication, and the way the medication interacted, you need to get to sleep at a regular time. And his doctor said that actually working these rotating shifts, specifically working night shifts, is impacting his health and it's making it worse. So he went to his employer with a letter from his doctor explaining that for medical reasons, he needs to work day shifts only.
Some accommodation.
Accommodation. That's exactly what he said. I think he even used that word. I really would like for you to accommodate me. The company looked at it very briefly and they said, we can't do that. Everyone works these rotating shifts. It's the way we've always done it. That's how our business operates. And if we do this for you, people are going to line up around the corner asking for the same thing. So we're not going to do it. He was very upset and concerned about his health. He was actually thinking about quitting, and he called me, and he wanted to know, can they do this, and what are my rights? Well, John, you used that word, accommodation. An employer has a very strict duty to provide accommodation. If you're suffering from a medical condition, if it's backed up by a doctor, the company has to accommodate. In some cases, that could mean modified duties, reduced hours, flexibility in terms of working from home, or it could mean changing your shifts, like in this case. His doctor made it clear he needs that for health reasons. The company has to accommodate. They don't get to say, well, it's a pain in the butt. They don't get to say others are going to want it as well. That may be the case. It doesn't matter. A company is under a very strict legal duty to provide accommodation, even if it's difficult. Now, their refusal to do that, John, means that this is a human rights violation. So he could potentially be owed human rights damages. But beyond that, this refusal can also be seen as a constructive dismissal. They have not complied with their legal obligations. They have not allowed him to continue working with his accommodation. It's as if they've fired him. Constructive dismissal. So not only can he get human rights damages, he can get wrongful dismissal damages. He can get his severance. The message here, the lesson is very clear. If you need accommodation, get something from a doctor. Okay, I want you to get a doctor's
note. Right? That makes it rock solid. Yeah.
You don't unfortunately get to decide. Your doctor gets to decide. But if the doctor says you need that accommodation, if the doctor says here's the modified duties, the hours, the changes that need to happen, your company has to do that. If they don't, that could be a human rights violation. Let's talk about that. I want you to reach out, to call or email, because the company is under a very strict obligation.
And to reach out, 1-855-821-5900. There's also help at employmenthour.ca. And employmenthourtv.ca is the place you want to go find our weekly radio show. We've been doing that for 7.5 years, I guess. We got a ton of calls on the show. We like to cherry pick some good ones, informative ones, and play them back here. And we comment on them, right? We got our first phone call for the day.
I've been working for the company I work for 10 years. I'm 63 right now. I've developed carpal tunnel syndrome with my arm and my wrist. Unfortunately, I'm not able to do the level of work that I was able to do in the past. I've tried to explain this to my employer. He doesn't seem to be taking it serious. My condition isn't getting any better. You know, the more I use that right hand and that right arm, it's only going to get worse. So I don't know what to do.
It's the accommodation hour.
It may as well call it that. It touches on exactly what we were talking about before, accommodation. So here's what he needs to do. What's not clear to me is if he's just spoken with his employer or if he's gotten the employer something from a doctor. Right. So to the extent that he has limitations, let the doctor say in writing what those limitations are. Not just to say he has a hard time using his right arm because of carpal tunnel. That's not enough. You need to say what the limitations are. Does that mean he can't lift things that are more than 10 pounds? Does it mean that he has to be sitting? I mean, what does that mean? Because once the employer is advised of those limitations, the employer has to accommodate. The employer then has to look at those limitations and try to find a job that matches those limitations. If the company still refuses, in this case, the company is not taking it seriously. And it's possible that they're not taking it seriously because he hasn't given them anything from a doctor. So give them something from a doctor and they have to take it seriously. If they don't, if they still say, we don't want to do it, we're not serious, we don't care, that's your problem, not ours, well, human rights damages, he's also going to be owed severance. That's a termination. So to finish the analysis, let's go to our friend, severancepaycalculator.com. Let's input his information to see what kind of severance he would be owed in this situation. So let's say he's in a technical role. We can see there on the screen, 10 years of service, 63 years of age. Obviously, he hasn't gotten paid anything, but his severance correctly is assessed anywhere from 14 to 22 months of payment, okay? 14 to 22 months of severance is what he'd be owed here. That's a lot of severance, a lot of compensation, and it's something that we have to take seriously. So severancepaycalculator.com, and remember, company has to accommodate.
And that accommodation doesn't have to be a week, 2 weeks. It can go on as long as he needs it, correct?
Absolutely.
With medical advice?
As long as the doctor supports it, as long as there's that need to provide accommodation for, the company has to accommodate.
Again, employmenthourtv.ca to find where you can catch our radio show. Phone call number 2 right now.
Last year, I worked for a company, one of the major telco companies. I got laid off. Question number 1, how much time do I have to take legal action for being terminated? Number 2, if I was fired because of the cause, would that leave me with any kind of a room to get severance?
Couple different things to unpack, right?
Couple different things to unpack for sure. So let's start with this cause idea. Yep. Obviously, we don't have too much information as to why this person was let go, but she used the word cause. And if you were let go for cause, it suggests that you've done something so bad that makes it impossible to continue employing you. That's a very high standard. Maybe you did something wrong, but that does not mean you can be let go for cause. Doing something wrong does not equal cause. Doing something terrible may equal cause. So that's a very big distinction. So yes, if what you did is not bad enough to be cause, you're going to be owed your full severance. I see this all the time. I speak with people every single week that are let go supposedly for cause because, yeah, maybe they did something wrong or their performance was not up to snuff, but that does not mean that that's cause, not even close. They're going to be owed full severance unless there's a long history, unless they've been warned, unless the company has done a really, really good job of building up its case. In most cases, they have not, and severance is owed. The second issue is how long do you have to pursue it, and this is important. This applies any employment case, really. It's 2 years. Now, it's not 2 years in a day or 2 years in an hour or kind of 2 years.
2 years.
It's 2 years. So once you are beyond that 2 year period, you're out of time, you can't pursue it. But it's important to remember, you do have that 2 years. So if something happened to you a year ago, a year and a half ago, you can still deal with that. You still have rights, you still have time to deal with it. Always call me, let's talk about that, but there's 2 years.
1-855-821-5900 is the way to reach out. This part of the show, I've been really looking forward to this for all week, and this is the true and false portion of our program today. And we decided, I didn't decide, somebody decided that it's going to be you asking me the questions, the guy who's not the lawyer in the room.
Yes.
That's how it's going to go. So this is going to be just, this is going to be charming.
Well, you know, we've been talking about employment law together for 7 years.
Right.
So you gotta, I hope you've
Really?
picked up on a few things.
Thanks.
If not, then I'm not doing a good job.
Right.
And you know, when we have these cards here, and I thought maybe the answers are going to be
I'm
on
not
the
looking.
cards. They're not on the cards,
Great.
actually. So I'm going to ask John some questions. John's going to give us his best answer, true or false. You have a 50% chance of succeeding. And then we'll elaborate a bit and talk about these things. So there's some important lessons here. We're going to touch on some important topics. So
Just
first,
rip off the Band-Aid, man. Start.
I'm going to start right now. First one. If you're disabled and you can't work, your employer can hire someone to replace you.
True.
That is true. Good start. That's true.
Yeah.
Your employer has a right to run its business.
Yes.
And that may mean if you're off and they need someone in your role in order for the business to operate, they can hire someone. It's very different in maternity leave, but with disability leaves, they can't. They can hire someone, and in fact, they don't have to fire that person when you're ready to come back to work. What they have to do is, if you're on disability leave and that you're ready to come back to work, they have to try to find you a position. If it's not the exact same role, it's a similar role. Oh. If that role doesn't exist, they've tried, they've looked, there's no possibility to take you back, then they can terminate with severance. But yes, a company is allowed to hire someone. The analysis, the assessment of whether or not you're going to come back to work is going to be done when you're ready to return.
So if the person replaces you as an absolute rock star and they want to keep them, they have the option to do so.
They have the option. They still have to try to find a position for you.
Okay.
They can't say, well, we're not even going to try, we're not even going to look. That could be a human rights violation, but they don't have to fire the person that's doing your job. Very different in maternity leave.
Right.
They would have to.
The true or false portion of the show, number 2. Okay.
Number 2, we're after a good start, though. So you must accept a demotion as long as your pay is not reduced.
I'll go with true. Okay, we're done here.
We're done. Thank you. I'm leaving. No.
That's right.
So that is false.
Right? Yeah.
That is false. A demotion suggests something negative. A demotion suggests a less senior role, a less prestigious role. And even if there's no pay reduction, it could still be a constructive dismissal. If you're doing a lesser role, but the pay will stay the same, maybe the company said, we're going to demote you, but we're going to freeze your hourly rate. We're not going to pay you less. You can still treat that as a constructive dismissal. A company does not have a right to demote you, even if pay stays the same. If they do, if it's a real demotion, if it's a lesser position, you can treat that as a termination.
Would the problem be if you go from a manager and they demote you with the same pay to, say, an assistant manager? Is it perception? Is it prestige if you go look for another job that you've been demoted? Is that
Absolutely.
the problem?
If you're going to put a lesser role on your resume, number one, there's going to be questions asked when you're looking for another job. It may be difficult for you to find a more senior position because you're going to have this lesser position on your resume. So all of those things are a big deal, which is why if you're facing a demotion, in many cases, you're better off not accepting it and treating it as a constructive dismissal.
Employment Hour 30, true and false. I'm in the hot seat. I'm going to get you back for this on another show. But number 3, what do you got?
So the next one, when you're let go, you should be paid for a bonus due in the future.
Yes.
That's absolutely right. That is 100% true because when you're let go, your severance is based on your total compensation. So if you usually earn a $30,000 a year bonus, as an example, you have to get that, or at least a prorated portion of that, when you're let go as part of your severance. So even though the bonus is not paid now, it's paid in the future, even though you haven't earned it yet, we look at your past history, and if you usually earn that bonus, it has to be paid as part of your severance, John.
Because your employer, sometimes they're going to try to be sneaky and axe you a week before the bonus and say, oh, too bad, so sad, you missed it.
Yeah, absolutely.
Yeah.
They could try to pick a convenient termination date. They could also try to say that your severance should only be based on salary because bonus is discretionary. Well, if you get it every year, it's not discretionary. So remember, bonus has to be included, and the company can't avoid usually paying a bonus by choosing a convenient termination date.
All right, true or false? Next question. Bring it on.
Well, we'll do one more here, Johnny, to keep you on your toes, and that is this one. If your employer did not approve your overtime hours, it means you won't get paid for overtime.
Did not approve, you won't get paid. That is false.
That is false. Yep. If you work the overtime has to be paid, okay? Even if the company doesn't approve it, and beyond that, even if the company said to you, don't work overtime, you are not allowed to work overtime, okay? If that happens and you still end up working it, you still have to get paid for it. Now, as long as it was legitimate. If you were simply sitting there so you can get paid, no. But if you had to do the work to get, or just to do the overtime to get the work done, the company has to pay it. Now, They may be disciplinary issues. They may be upset that you worked overtime when you weren't supposed to, but they still have to pay it. So overtime, if it worked, and generally, John, overtime, 44 hours a week, anything over that, you get time and a half. Hourly and salary applies just the same, even if the company doesn't approve it. If you had to work to get the work done, company has to pay for it.
We've talked about it, used it several times already on the show, but we're going to dig into it even deeper. Severance pay calculator is coming up after a short break. 1-855-821-5900 to reach out. Employment Hour in 30 continues. Don't go anywhere.
You lost your job. They only gave you 2 weeks of severance per year worked. But where can you find out what you're really owed?
I'm going to severancepaycalculator.com.
Find out how much you're owed right now. Severancepaycalculator.com.
You've been denied long-term disability. You think you're powerless, but you have a lot more power than you think. I'll tell you a secret. It's a numbers game for the insurance company. They're betting on you walking away from money that they owe you. Don't make that mistake. We resolve disability claims all the time. We force insurers to pay what they owe. We're in your corner.
Call Savan and his team, 1-833-IN-YOUR-CORNER, or go to inyourcorner.ca. You were being harassed, and when you said something about it, you're the one who lost your job. Now what are you going to do?
I'm going to employmentlawyer.ca.
Always check with the employment lawyer first at employmentlawyer.ca.
And welcome back to Employment Hour in 30. This is the portion of the show where we introduce you, if you have not been so far, but what 500,000 people have, that would be the severance pay calculator, the best and easiest way to find out exactly what you're owed. But that's just an overview. Give me some details on it, pal.
Well, severancepaycalculator.com, so easy to use. You grab your smartphone, you grab your tablet, whatever it is, and you go to severancepaycalculator.com to find out the value of your entitlements. It's as simple as that. Maybe you're staring at that severance letter and, how am I going to know if the 6-month severance offer is good enough? Well, you go to severancepaycalculator.com. It's that easy. Or maybe you have a meeting coming up on Friday and you think they're going to let you go. You want to be prepared for that. Or you're concerned about what's going to happen down the road. Maybe the business is being sold. There could be so many reasons to find out, to know what your entitlements are. So go to severancepaycalculator.com. And once you're there, you're going to be asked 3 questions. Your age, your position, the length of your employment. And once you answer those, you're going to find out how many months pay you're actually owed, the real amount, your full entitlements. We also call those common law entitlements. It's not a week's pay per year of service. It's not 2 weeks' pay. It's a lot more than that. And it's anonymous. It's free. There's no place to put in your credit card, so don't bother looking. You can't. You don't have to put in your name. You don't have to put in the company's name. And of course, once you've gone through that exercise and you know how much severance you're owed, if you want, and only if you want, there's a little green button there. You can press it to contact me so that I can help you get what you're owed.
You know, it's such an important tool because so many people are still under the misconception of a week per year, 2 weeks per year, or, their Uncle Bill has told them that, no, that's all you get. You're good to go. Sign it, right? Don't do it. Go to Severance Pay Calculator.
Absolutely. Don't do it. Call me if you don't want to use the calculator, but it's so easy. You can do it any time of the day. It works. It literally takes seconds. Right. SeverancePayCalculator.com.
I'm going to run an example through the calculator now, and we'll see what comes out the other side. 46-year-old Sheila worked in sales at the same company for 16 successful years, earning $74,000 a year. It's a good salary. One day, the new sales manager pulled her into his office and let her go without any explanation. Okay, he offered her, 32 weeks of pay, severance pay. Is that enough?
Think what a shocking thing that is. You work somewhere for 16 years, you're let go, no explanation, no reason. And most people are going to be quite struck by that. Most people are going to react very harshly to that. And the reality is it's not a nice thing to do, but legally speaking, we've said this before on the show, a company is allowed to let you go pretty much for any reason, pretty much at any time, as long as severance is paid. So legally speaking, the real question in this case is not why is this company letting Sheila go without warning after 16 years. The real question is how much severance, exactly. Severance that's owed to her. They have offered her 32 weeks. Is it good? Is it bad? Let's not wonder. Let's plug her information into the SeverancePayCalculator.com website right now. You see it on the screen there. She's in a sales role, 16 years of service, a long time. 46 years of age. They've offered her 32 weeks pay. Well, Severance calculator correctly assesses her as being owed 16 to 20 months pay. 16 to 20 months pay. And her compensation, that's a difference somewhere between $50,000 to $77,000. That's a lot of money. That's a lot of, that's a big difference between what they've offered her. And this is a true situation. We didn't make it up. And we didn't bring it up here because it's unique. It's not. It's common. That's how easy it is. Remember, it's not about why they let you go. It's about how much severance you're owed. That's why severancepaycalculator.com is so important.
You know, it's amazing the difference there, another year of pay. It's not only just a year of money, it's a year of benefits, of possible, you know, car allowance, bonus. We discussed.
Yeah.
It's lots.
Just the benefits. Can you imagine having the benefits for 14 months instead of 30 weeks? Huge. You know, you may have kids, you may have a significant other that rely on those benefits, dentists, prescriptions, what have you. It's a big deal to get the severance right. It's not just salary, but severancepaycalculator.com works just the same.
EmploymentHourTV.ca, that is the website to go to find the radio show. Do so, listen in on the weekends and during the week if you can. If not, we play some phone calls back on this TV show and we talk about it. Here's another call.
I was dismissed without cause on a Wednesday, and I was told that you have to sign this document by Friday or everything was null and void, and I didn't know any better. With all these big companies and their massive HR departments against the lonely little employee that doesn't know anything, why would they get away with this?
Because they can.
Because they can.
do.
Yeah, and at the end of the day, the company is simply saying to you, hey, you better sign this, but they're not physically threatening you. They're not, blackmailing you. They're not doing any of that. So they're saying, you know, this is our offer, sign it if you want it. But the reality is, if you lost your job, you're not in the right or the best state of mind. You just lost your job. You're worried about paying your bills. You're worried about, how you're going to support your family, how you're going to find another position. And now they've offered you some compensation, and you're concerned about losing it. And that is the key here. It's not a good time to make a decision, and frankly, many companies count on that. That's why a lot of people accept severance before they get advice and when they shouldn't be accepting it. So that deadline, don't worry about it. You can ignore it. Your legal rights don't expire Friday at 5 or whatever the date is in your severance letter. They don't expire. I said before in the show, you have 2 years to pursue your rights. So that's the key. You go to severancepaycalculator.com. You call me. You don't like me, you call another employment lawyer. That's fine. Your job when you lose your job to make sure that you get what you're owed. Don't count on the company. They're going to ultimately do what's best for the company. That's fine. It's your job to look after your interests, your rights. That's why severancepaycalculator.com works so well.
The validity of a doctor's note deadline, we'll get to that after a short break. 1-855-821-5900 and employmenthourtv.ca as well. So Employment Hour in 30, stick around, coming right back.
You lost your job. They said they had a good reason, but you think you've been wrongfully dismissed. Now what are you going to do?
I'm going to employmentlawyer.ca.
Always check with the employment lawyer first at employmentlawyer.ca.
Insurance companies deny long-term disability claims all the time. They give lots of excuses. Don't give up. I've seen it all. They've ignored your doctors, they've ignored you. You're angry and you're frustrated. But there's hope. We resolve disability claims all the time. We force insurers to pay what they owe. We're in your corner.
Call Savan and his team, 1-833-IN-YOUR-CORNER, or go to inyourcorner.ca. You thought you had a secure job. You didn't see it coming. Now what do?
I'm going to employmentlawyer.ca.
Always check with the employment lawyer first at employmentlawyer.ca.
Hi there, welcome back to Employment Hour in 30. EmploymentHourTV.ca, as I mentioned a couple times during the show, is a place to go to find a radio show near you where you will catch Employment Hour, which we've been doing for over 7 years. On that show, of course, a lot of interested listeners want to find out exactly what's what when it comes to their workplace rights, so they call us, we take them on the air, and we answer them, just like we'll get to another call right now.
I was on stress leave from my job, and they asked me to supply a note by a certain date from a doctor's note to extend my medical leave. I called to try and book an appointment with my doctor, but I wasn't able to get in the day after their deadline was. They served me the day of my doctor appointment and fired me because they said I abandoned my position. I was there for 3 years. I was in inventory management. I'm 50.
Yeah, that's all wrong.
It's wrong, and I actually remember that call on our radio show because it's silly. Can you imagine? Oh, you have 24 hours to get us a doctor's note. Well, good luck trying to get into seeing a doctor in 24 hours.
Right.
It's never going to happen. So, what do you do in that situation? Well, normally what I would tell the company is, once you've scheduled a doctor's appointment, just so you know, employer, my doctor's appointment is not for another 3 days, whatever it is, and then I'll get you the doctor's note then. But even if you haven't done that, the company can't say that you've abandoned your job because you couldn't comply with an arbitrary deadline that they've imposed. It doesn't work that way. And if there's a medical condition, by doing that, that could be a human rights violation. So if you need to provide a doctor's note to justify an absence, to show that you need accommodation, to justify why you can't work for a foreseeable time in the future, tell the company how long it's going to take you. And if they're not reasonable, if they're not going to cooperate with you, they're going to do what this person did or this employer did and treat your employment as being terminated, that's a wrongful dismissal, potentially also a human rights violation. So she did nothing wrong here. She's owed severance. So again, let's plug her information to severancepaycalculator.com to see how much severance she is owed. So she's an inventory manager. It's a managerial position, 3 years of service, and age of 50. I don't know her salary. I picked, let's say she makes $65,000. Obviously, she was not offered any severance. Her employer says incorrectly that she abandoned her job. Well, Severance Calculator correctly assesses her as being owed 4 to 6 months of pay. So that's how easy it is to use the calculator, and that's how important it is to make sure that if you're not agreeing, if you're not really abandoning your job, if you're not deciding that you don't want to work there, if the company made a decision for you that you've abandoned, that's almost always going to be a termination. The only one that can decide if you've abandoned your job, if you quit, is you. If the company decides that for you, more often than not, that's going to be a termination. And we just looked at the calculator to see how much he's owed.
And you mentioned disproportionate severance, 3-year employee, and look how much severance, up to 6 months severance.
And very common. Remember the rule that short service employees are often treated disproportionately better than longer service employees. I'm talking about employees with 5 years seniority or less. So it's very common for someone that worked for a couple of years to get a few months severance. It's even common for someone that worked for a few months to get a few months severance. So if I haven't convinced you by now, I don't think I'll ever convince you.
Right.
You really got to check out severancepaycalculator.com.
Another place for you to go to ask questions, have them answered quite readily, terminationquestions.com. Again, terminationquestions.com is where you want to go. Pull an example from it, Lior. We got a question on that website. It says, I was laid off from a federally regulated company after 19 years. They made us sign new contracts a few years ago. That limited our severance, which isn't good. If we didn't sign, they were going to fire us, apparently. So my severance pay is 12 and a half weeks. Can I fight this? Should I fight this?
Well, number one, I want to see that contract, and I want to find out more about the circumstances that brought about the signing of that contract. So if you're already working and the company says, sign this contract or else, in most cases, that contract is not going to be enforceable. Some companies realize, well, wait a second, we have these really extensive obligations to our employees when it comes to severance. How do we limit those?
Yeah, right.
I know how. Let's get them to all sign contracts that limit their future severance. The problem with that is that if you're not giving them something in return, if you're just saying sign here and that's it, and they sign, that's probably not going to be enforceable. For a contract like that to be enforceable, the employer would have had to give the employee something in return.
Like a signing bonus or something?
A signing bonus works beautifully. Yeah. A pay increase, extra vacation, a better benefits plan, a promotion, something of value. If the employee just signs that agreement, it's not worth it, it's not enforceable, it doesn't really mean anything. So this person may well be looking at an agreement that's not enforceable, and if they're let go, they're going to be owed full severance and not what the contract actually says. Happens very often, and there's many reasons why your contract may not limit your entitlements, even though it tries to do that. I don't want anyone accepting severance because they assume that their employment agreement or the contract of employment limits their severance. And finally, this person says that she's federally regulated.
Yeah, what is that?
Federally regulated employees work for banks, railways, TV, radio, but their full severance entitlements are the same as everyone else. Just because you work for a federally regulated employer does not mean you don't get severance. In fact, you get the same severance as every other employer. You can check out severancepaycalculator.com in the same way. There's a big misconception. Not true, John.
Done for another day. You want to reach out, help at employmentlawyer.ca, employmenthourtv.ca to find where you can catch the radio show or the good old-fashioned phone call. 1-855-821-5900 is a good way to go, and we mentioned it several times today. Always use it. Always check it out. First place to go is free. It's easy to use. severancepaycalculator.com, and there's a button at the bottom. You can either contact or not contact Lior and walk away with that knowledge for all time. Again, severancepaycalculator.com. Thank you for joining us. We'll catch you again right here on Employment Hour in 30.
Closed captioning of this program is brought to you in part by SeverancePayCalculator.com. Find out how much you are owed right now. SeverancePayCalculator.com.